Okay, good evening, everybody. Thank you again for coming. Hope you've enjoyed these sessions as much as I have enjoyed. I've learned an awful lot, believe it or not. I've been doing this judging for 18 years, and I learned so much, okay? Today we're going to find out about the trial. Our hero, Mr. Defendant, I think is going to be going to trial today, picking a jury, and Judge Tanya Wilson is going to be talking to us, and she is a font of knowledge. Trust me. I think it was last week, the week before, she texted me in the middle of the night, like frantically. I mean, literally in bed. Bob, I think I need 2 hours. I think I need 2 hours. And I'm like, no, Tanya, you get an hour and a half, okay? And I'm going to burn 5 minutes of that bragging about you, okay? But it is my pleasure to introduce Judge Tanya Davis Wilson. She's currently, she's a circuit judge currently, and she's in circuit civil, but she has very large and in-depth background in criminal court, as we will discuss. Over the course of Judge Wilson's judicial career, she has served in a wide range of assignments, including criminal, domestic relations, juvenile delinquencies, Jimmy Rice Act matters. She brings a depth of experience that reflects both versatility and a strong commitment to public service. She's also held leadership roles here in the Ninth Circuit as well. She's served as the Associate Administrative Judge for Osceola County and Circuit Courts. Before her service on the bench, Judge Wilson served as a county court here in Orange County, and she handled criminal matters there. She's a double Gator graduate, proud, both undergrad and law degree from the University of Florida. Beyond the courtroom, Judge Wilson's commitment to the community is also impressive. She has been deeply involved in numerous professional and civic organizations, including the Orange County Bar Association, the Paul C. Perkins Bar Association, the Central Florida Association of Women Lawyers, and the Orange County Bar Association Foundation, and she has actually served on the board of directors for the foundation. Her service extends even further through work with organizations focused on youth and education, one of the many things I like about Judge Wilson. She's a co-founder of an organization called For the Kids Incorporated, which provides critical services to underprivileged children. She has also volunteered her time as a judge for high school mock trial competitions, and she's been a lecturer at Valencia College of Law, the Law Enforcement Academy, which they teach at Valencia. Her contributions have been recognized with multiple honors, including the Distinguished Service Award from the Florida Council on Crime and Delinquency, and she's been the recipient of a Woman's Voice Award. Simply put, Judge Wilson exemplifies what it means to serve both the law and the community with dedication and purpose. And it won't surprise you because I said it last week. She's also one of my favorite people. Okay, so please help me welcome Judge Wilson.
All right, so that check is in the mail as soon as he... Well, welcome. I'm so glad to be here with all of you. I literally was just in this courtroom an hour ago. I'm in the middle of jury selection now, and I'm like, y'all, we got to get out of here. But we didn't get out of here until 5:10, so give me a minute to like woo-saw because I changed. I came back down, and so now we're here. We're ready to go. And we are going to do the trial involving Danny Defendant. Poor Danny Defendant. He didn't want to take the plea. So he is going to have to go to trial. And so what we're going to do today is we are going to talk about the anatomy of a trial. Like, what are the bones? What are the structures? What are the muscles, the ligaments, and all of that for a trial, hence anatomy of a trial. We're going to have an introduction, and you'll see everything that's in your workbook. Did you all get the workbook? Okay. Handy dandy workbook. Hopefully I will be able to follow along with you. But these are the table of contents, and these are the things we're going to go over. We're going to go over the jury selection and opening statement, cross-examination, direct examination. By the time we're finished, you are only short of being a lawyer by not taking that bar exam, because I'm going to make sure that you are able to know what a good cross-examination is and what a good direct examination is. Then we're going to learn a little bit about constructive possession, because remember, some of the things that Danny Defendant had were not on his person. They were kind of like in the car. So we have to figure out, is that a good defense for him or not? You'll be able to tell. You will also be able to do a closing argument without objections being called. That should actually say jury instructions and verdict form, and then we'll do sentencing. You are actually going to be able to vote. You're going to have a QR code. It goes to a Google form, and you're going to be able to vote, and you'll let me know if Danny defendant is guilty. That's the bio. We'll keep going. Learning objectives. You're going to understand each phase of the trial. You're going to recognize how the evidence is presented. And you're also going to get some insight into how we as judges apply the law. You're going to understand a little bit more about our decision-making process and what we think about when we are sentencing individuals. I will tell you this, and I think y'all might agree. The hardest part about this, in criminal especially, is sentencing. It's hard because you've got a victim on one side, and that victim wants justice, and then the defendant on the other side, and the defendant wants mercy, and you have got to somehow figure out, okay, how do I balance all of this? So you're going to understand a little bit more about our processing. Here's the digital workbook. If you'd like to have it on your phone, you can take that picture of that QR code, and that is, you'll be able to download it there. And so here's a quote. In this country, our courts are the great levelers. Who said that? Anyone know? In our courts, in this country, our courts are the great levelers. Atticus Finch. He said that in his closing argument in To Kill a Mockingbird. And when you think about a jury trial is an opportunity for individuals to be able to have their grievance addressed by a jury of their peers. The idealistic goal, or the goal that we hope that we're able to reach, is that it's fair for everyone. Everyone is going to have a fair shot at getting their case heard, that they will have a fair and impartial jury hearing their case. And so when you come here, it's not a bias one or another. It's actually, you start off on a level playing field. And that works out well because when you're talking about jury selection, which is our first part, you're talking about fairness, impartiality, and open-mindedness. That's what I'm trying to do today. Did not pick a jury, though. We got to come back tomorrow, and we'll see how that goes. But one thing that you will hear if you are selected as a juror is that what we are trying to do is we are trying to get people who are fair and impartial. And so you're like, well, what is fair and impartial? Fair and impartial is an individual who can take the facts of a case. Jurors are essentially judges of the facts. You're going to take the facts of the case, you're going to take the law that the judge will give you, put the two together and make a decision. And that makes you fair and impartial. We do understand that all of us have some sort of bias or prejudice, right? I mean, our life experiences have colored the way we think and colored the way we make decisions. So the question then becomes, can you put that aside? And can you just look at the facts, look at the law, put the two together and make a decision? And if you can do that, you're fair and impartial for the most part. That's all it is. And that's what we are looking for in our jurors. So some of the qualities, we need you to remain open-minded. Don't come to your jury selection or to your jury service if you are selected with a closed view. Be open and be willing to listen to the evidence that's being presented. We need you to follow the law. You're not going to agree with it all the time. Some things you're just going to disagree with. But you have to be able to follow the law because if you don't, you're not the great levelers. You're not leveling the playing field. Please set aside personal differences and just evaluate the evidence fairly. What does the law say? What are the facts? I'm going to make my decision. Quote down here, fairness is not perfection. We're not looking for perfect people. None of us are perfect, can't be. Just can you follow the law? That's what a fair juror is. And so a fair juror in this case, well, what does Danny defendant have? He had marijuana, a gun, and pills. What did we say those pills were? Are they oxy or are they fentanyl? Oh, oxy, okay, so he had oxys, a big bag of those. So can you think of who might not be a fair and impartial juror in a case like that? Or like the one we have? Who might just, Answer out loud.
Someone who lost a family member to drugs.
Right, you lose a family member to drugs. You might not be as willing to be open, and you might not be able to put that aside. Any others? Who might not be a good juror? What about someone who is a really anti-gun violence, anti-gun, don't possess it, I don't care what the Second Amendment says, you should not possess a firearm? Would that person be able to be fair and impartial for Danny defendant? No, you don't want that one either. Someone who might be, hey, pro legalize marijuana. He's going to want that one, right? But who won't want that one? The state. So there's a process by which we go through and we select jurors. There are 3 tools that we use. One of them is a Florida statute. You can look this one up. 40.013 actually lists qualifications for when we can excuse a juror for one reason or another. Starts off, if you are the governor, the lieutenant governor, if you are a judge, a clerk of court, you are excused. You are disqualified. You can't serve. If you're a convicted felon and have not had your rights restored, you cannot serve. If you are an expectant mother, you can be excused if you ask. If you're a student between the ages of 18 and 21 and you're full-time, you can ask to be excused. So there are different criteria, and we just went through some of those today. Here's an interesting one. Individuals who do not understand English can't serve because the trial isn't conducted in a different language, and when they go back in the jury room, they can't have an interpreter back there. So you can only send 7 in the back or in the jury room, so if you needed an interpreter, they would not be able to serve. So you can remove jurors for those reasons as well. You must live in Orange County in order to serve on a jury here in Orange County. And even though our circuit encompasses 2 counties, you can't live in Osceola and serve on an Orange County panel and vice versa. There are certain hardships. Okay, y'all look. I'm not advocating that you use these to get out of service, but I got a feeling that if you're in here, you won't try to get out of it. But sometimes if an individual has a prepaid vacation, they're going to the Mediterranean, they're on a cruise or something like that, that's a hardship because they're going to lose that deposit, right? So we don't want to have those people to have that undue hardship. Jury service is going to be hard sometimes. I'm in the middle of a trial right now, and I told the jurors that it's going to be about 6 days. And I had a few people who were like, I'm out of here. I don't care what I got to say. I'm out of here. I'm not sitting here for 6 days. And I understand that because you lose money, especially if you're a small business owner. So those are the undue hardships that we're looking at. Challenges for cause. A juror just can't be fair and impartial. I hate the police. I can't stand Officer Law. I don't like the city of Windermere, and I am not going to be fair and impartial. And if Officer Law testifies, I'm going to know I'm going to discount his testimony. That person will be challenged for cause because they cannot be fair and impartial. Individuals also can be removed when there's a peremptory challenge. So a peremptory challenge, you can remove anyone for any reason as long as you are not being discriminatory in your strike. So each side, is that me? Okay. Each side has, in a civil case, each side has 3. In a misdemeanor case, each side has 3. Felony cases, each side has 6, unless it's a death penalty case, and there it's 10. However, if you have multi-defendants, let's say you have 2 defendants on a felony case, and they would have 6 apiece, well, then the state gets 12, because we are the great levelers, right? So 3 ways to remove them: the statute, challenges for cause, and peremptory challenges. Jurors that he's going to want on his panel are those who are pro-gun, pro-marijuana, overlook the pills maybe. The ones that the state might want are the exact opposites. They're going to want those that are anti-gun. They're going to want those that will not want marijuana legalized. So here's some other considerations. These are the questions that when I was in criminal, I would ask jurors. As Danny defendant sits there, do you all agree that he is innocent at this point, because there is a presumption of innocence. You might have walked into court and you might have seen him and said, hey, what did he do? But do you all agree that as he sits there, he is innocent? Because what evidence has the state proven? None. None. So he is cloaked with this presumption of innocence unless the state can prove that he's guilty. What's the standard? Beyond a reasonable doubt. So that leads into the next one. I explained to them what the burden is. The burden is on the state attorney to prove the case because they were the ones that filed the information. They charged him with trafficking, possession of a firearm by a convicted felon. They charged him with possession of the marijuana, possession of paraphernalia. So if they want to bring the charges, then they need to be able to prove it, right? Prejudging a witness's credibility, I will ask, how many of you would give Officer Law more credit to his testimony just because he's an officer? Some people will say yes. Anyone in here would? Anyone? Okay. And why would you give Officer Law more credibility than you would any other witness that might have come in?
Because he's experienced, he's been trained, he understands the law, and he understands what the situation is in terms of what could possibly have been items that broke the law.
Same answer for you? Okay. And I agree with you. I agree with you. He is trained. He is experienced. But because jurors are the what? Great levelers. He has to have the same, you have to give him the same amount of credit that you would any other witness. So they come in and you have to wait and you have to sit there and you have to listen at what he's going to say. In the workbook, in the appendix, I gave you an instruction that said witness credibility and how you can judge witness credibility. And your witness credibility, did the witness seem to know the things about which the witness testified? Did the witness have honest and straightforward answers? Because if someone is hemming and hawing on the witness stand, what does that make you feel like? Yeah, you're lying. So if a witness comes across and they're straightforward, okay, well then I think he's believable. I think she's believable. So there are questions that along those lines just to make sure that you won't prejudge a witness. You won't judge a book by its cover. Right to remain silent. So let's say you are the panel and I'm asking you the questions because these are my little questions that I get to ask. The defendant has an absolute right to remain silent. It is just as important as the Second Amendment right to possess firearms, or in civil, the Seventh Amendment right to have a civil trial. The defendant, Mr. Defendant, Danny Defendant, has a right to remain silent. He has a right not to testify. And if he doesn't testify, you can't hold that against him. As he sits right now, if he does not testify, will you hold that against him? Anyone? No. No? Anyone want to hold it against him? Y'all, somebody say yes, just pretend. You would. Okay, so why would you? Why, what do you want to hear from him?
Because if he doesn't want to testify, what is he holding back?
Okay, does anyone else feel like that? If he doesn't testify, what is he holding back? Yes, ma'am.
I want to hear his side of the story.
So you want to hear his side of the story. Miss Gora, you know I know your name, so I'm going to call you out. Miss Gora, you said, you nodded back like, yeah, what she said. Does anyone else want to hear his side of the story? So how do you make your decisions when you are trying to decide between two different things? You hear this person's side and that person's side, right? Right? So that's where you want to hear his side of the story. But when we are in a court of law, the rules are different. The rules are different. We abide by rules of evidence, rules of criminal procedure. We abide by the Constitution, Florida, and the United States. And all of those laws are premised under the fact that he has a right to remain silent. And think about it. Why? Because it's their job to prove that he's guilty. He shouldn't have to incriminate himself or testify and explain why he's not guilty. They have to prove that he is. So once we get through those 4 questions, typically we have enough challenges for cause because people are like, look, no, if I don't hear his side of the story, then I'm not going to be able to make a decision in this case. Opening statements. Let's hear an opening statement. An opening is a non-argumentative roadmap. Did Mr. Gambini give the jury a non-argumentative roadmap? Not even close, right? Not even close. That's the opportunity for the attorneys to tell you what they think the evidence is going to be. The witnesses, maybe that's the time when they'd like to introduce the witnesses. Ladies and gentlemen, Officer Law is going to testify today about the stop that he made in the city of Windermere. He's going to tell you, yeah. He's going to tell you, blah, blah, blah. It also is an opportunity to preview the witnesses, the exhibits that the jury will hear and see during the trial. Officer Law is going to testify that he found however many grams of marijuana and however many grams of oxy, and he found a gun. And you're going to be able to see all of that during the course of the trial. That's just a roadmap, and that's all an opening is. It is not what Mr. Gambini did. It is not arguing. It is not telling the jury what kind of verdict to return. You don't say, or the state doesn't say, you're going to hear the defense and they're going to try to tell you this. That's objectionable. And you can't argue credibility. You should believe Danny defendant over Officer Law. That's what it's not. But if you can't remember that slide, please remember Mr. Gambini when he did his opening by simply saying everything that person said is BS, because that's what it's not. So you make the call. Ladies and gentlemen, Danny defendant is clearly guilty. You're going to hear from witnesses who will prove it. The defense is going to try to confuse you, but don't you fall for it. And by the end of this trial, you'll know exactly what verdict you should return. You're now the judge, and there's an objection. Are you going to sustain it, or are you going to overrule it? Sustain. You're going to sustain it. Very good. So what's the fix? How do you fix this? How do you fix that? What should you say instead? First sentence. Yes, ma'am.
The evidence will, can you say the evidence will show that the defendant is guilty?
Almost. You can say the evidence will show that you're trying to prove possession of cannabis. So what's the evidence going to show? That he possessed marijuana. The evidence is going to show that he knew that that firearm was in the bag. The evidence is going to show, if you can start your sentence off, or if you're ever sitting on a panel and you hear them start off the word with, the evidence is going to show, that's right. So the evidence is going to show that he possessed X, Y, and Z. You're going to hear from witnesses who will prove it. How do you fix that? I heard it. Say it again.
You're going to hear from Officer Law.
Yes, you're going to hear from Officer Law, and he's going to tell you how he found all the evidence. Very good. The defense is going to try to confuse you, but don't you fall for it. I don't even know how you fix that one. I think you just exit out. Just X that one out. And by the end of the trial, you'll know exactly what verdict to return. That's a little sketchy. I probably should have done that one a little bit more clearly, but you don't want to just reference that the verdict. You can say, I will come back to you at the end of my closing argument, because that's a roadmap, right? I'll come back after the end of my closing argument and we'll discuss the verdict. That's probably as safe as you can go with that one. So you've gotten the fix. Ladies and gentlemen, this case involves a traffic stop in Windermere. You will hear that Officer Law saw the car roll through a stop sign and initiated a stop. The evidence will show that what Officer Law saw, what was found in the vehicle, and how Danny defendant responded. At the end of the evidence, you will have a clear picture of what happened. Simple fix, simple fix. So direct examination. So what's going on with direct examination? Anyone want to take a stab at that one? What's going on with the direct? When you have direct examination, that's the opportunity for, let's just say, the state, to make it simple. That's when the state puts on their evidence and they're able to put on their witnesses, and they have to tell the story. This is telling the story through the witnesses. Every story has 6 questions. Who, what, when, where, why, how. Those are the questions that the state attorney needs to be asking. Who did you stop? Where did you stop them? When did you do it? Where was it? Why did you stop him? How'd you do it? And you can see already, even though you all know the story very well, you can see how that would lead the jury to be able to understand the sequence of events. And so a lot of times state attorneys will just have their questions. When I was a federal prosecutor, I literally would have my questions lined out. And they were who, what, when, where, why, and how. Because I knew I needed to get the jury to hear the story and to be able to picture it in their mind. The purpose is to present the facts clearly, to introduce the evidence, and to help the jury understand the sequence of events. That's it for direct examination. There really isn't any more to it. Sometimes attorneys might get caught up and they might do a leading question, and we're going to learn about those in just a second, but they might ask a question in a leading way that begs an answer. That would be objected to because it's not a who, what, when, where, why, and how. For our cross-examination, for the purposes of cross-examination, that is where the defense attorney has the opportunity to poke holes in the case. So on direct examination, the state attorney is going to talk with broad strokes, okay? They're going to paint this wonderful picture, this beautiful canvas of what exactly happened. But then on cross-examination, it's the defense's job to get up and poke holes through the case. And so it also exposes weaknesses and it exposes inconsistencies. Here are the rules. It is going to be imperative that the attorney control the witness. And the way you control the witness is you got to keep those questions short and tight. Isn't it true that you, whatever? Isn't it true that, whatever? You might start off your statement and then say, isn't that right? So you lead with every question. The attorney is actually supplying the facts. You're not going to argue with them, and you never ask a question that you don't know the answer to, because as soon as you do, that witness is going to blow your case up in a major way. So you don't ask questions on cross-examination that you don't know the answer to. Here are the goals. We want to limit the witness's ability to expand the story, and we want to highlight any weaknesses, reinforce our own theory, control the pace, and secure admissions that are going to matter. Isn't it true, officer, law, that you asked Danny defendant questions about this case and you did not read him Miranda? Very tight. There's only one answer he can say if he's telling the truth. And what is that? Yeah, I did that. So you just want to make sure that all of the questions that you ask on cross-examination have a point. One of the things that we learned is that maybe like 4 or 5 points. We're not trying to be like F. Lee Bailey and stand up here for like 2 or 3 hours and cross-examine a witness. What you're trying to do is just come through with really quick points in order to challenge his credibility. If you had another witness that might have been a convicted felon, isn't it true that you have been convicted of a felony 7 times? Danny defendant, if he takes the witness stand, what's a good question that the state might want to ask him? Isn't it true that you were convicted of a felony? Even though it was something minor, he's been convicted of a felony. So that's one way to judge their credibility. Because just right now, if you were on the panel and you hear that there's a convicted felon testifying, how do you judge his credibility? What do you feel about that particular witness's credibility?
You might doubt it.
You might doubt it, exactly. You might doubt it, especially if the person also has been convicted of a crime of dishonesty. Okay, so you're just a liar. So you're not gonna, that's gonna be one of those questions on judging witness credibility that you'll have to work through as well. Oh, this is not what you think it is, trust me. This is not the one where you can't handle the truth. This is a different one. This is at the beginning of Lieutenant Caffrey's cross-examination. The reason for that particular clip is for you all to see what Tom Cruise's character was doing in terms of containing the witness, asking purposeful questions. The gist of the movie was that Santiago was a Marine who wanted to be transferred. He had asked to be transferred and did not get the transfer. Instead, Colonel issued a code red, and the code red meant for them to kill Santiago. So he had a purpose in the questions that he was asking the colonel. But what I want to ask you is, did you hear how often he said, "Is that right?" That's a cross-examination question. Granted, he called this witness, he probably treating him as a hostile witness, but he asked questions like, "Isn't it right? Isn't that right?" He also asked, "I noticed you wore your classy uniform, right?" Because the answer is either a yes or a no. But in this one, the answer would be yes. You brought your dress uniform with you. Not in "is that right," but just you brought your dress uniform with you. That's the character actually testifying to the jury, because that's what your cross-examination is. Cross-examination, you will hear the attorney stand up and they were asking the questions and they are actually testifying because they just want that witness to say yes or no to their answer, because that's part of their story. You also heard one question where he asked, why wasn't he packed? He had, after the arrest, the room was sealed off, and then he outlined all the items that were left. Why wasn't Santiago packed? That's him asking a question he knew the answer to. But he needs to get the jury to understand, or for them to be able to focus on, well, wait a minute, well, why wasn't he packed? So a lot of times the questions on cross-examination, yes, they show inconsistencies, but they also bring to light those points that the attorney needs the jury to pay attention to. And that was one. One more thing. Oh, you can clearly see how Tom Cruise's character is testifying. That is a goal of cross-examination. He's not going to get up there and ask the who, what, when, where, why, and how questions. That's not for that witness. For the witness who was hostile, like the colonel, you're going to ask those cross-examination witness. Can you explain that? Another open-ended question, but it's leading up to a point that he wants to make. The next clip afterwards, or the next part of the movie, you know that's the "you can't handle the truth" part, because then the colonel comes back, there's more cross-examination, and then the colonel gets really mad at him about that one. So far we've picked a jury. We've got jurors on the panel who can be fair and impartial. We don't have people too far on one side or another. We've got people who are going to be fair and impartial. For our opening statements, we're not going to make the Mr. Gambini opening statement. We're going to give a roadmap and tell the jury what the testimony is going to be, what the exhibits are going to be, and they're going to learn the story in the opening. And after the opening, the state is going to present their witnesses, and they are going to ask what questions? 6 questions. What are they asking? Exactly. So they're going to be asking those questions because that's going to give them the sequence of the events. After the direct examination will be the cross-examination, where Danny, defendant's attorney, is going to get up and he's going to ask leading questions of Officer Law, questions that will just attack his credibility, questions that will challenge what he actually saw. There might even be questions that might help the defense. And the defense in this case, we know, is constructive possession. So did you all talk a little bit about constructive possession last week? No? Okay, because that was for me. Constructive possession. What the state is going to have to prove, because did Danny have anything in his hand? Did he have anything in his pocket? A lighter? Was he charged with the lighter? No. But he had the lighter in his pocket. Did he have the gun, the drugs, the marijuana, or the pills on him? All in the car. If he had, that would be called actual possession. And then you'd be like, well, Danny, why in the world are you not taking the plea? You had the gun on you. Here, none of the items were on him, so the state has to use the theory of constructive possession, meaning he had knowledge of the items and he was able to exercise dominion and control. With constructive possession, like I said, actual possession isn't required, but you gotta have more than him just being close by. Proximity is not enough. So just because the book bag was in the back seat and he's close to it because he could probably just reach back and get it, that's not enough. Shared possession is actually possible. So let's say Danny had a friend in the passenger seat with him. They probably could get shared possession on the marijuana joint that was on the console, and probably in the stuff in the back seat as well. But the thing about constructive possession you understand is knowledge. He knew that it was there. You have to prove that he knew that it was there and that he exercised dominion and control. Did the car smell like marijuana, burnt marijuana? Yes. And there was a joint there on the console, and he had what in his pocket? What does that tell you about the possibility of Danny having possessed that marijuana joint? Pretty good, kind of high, right? Beyond a reasonable doubt? No? Okay, all right, fair enough. Here are the elements: knowledge, dominion, control, shared possession, application. So with knowledge, what facts show that the person knew the item was there? For Danny defendant, what facts show that he knew that book bag was in the back seat? Anyone?
He said it was his cousin's, I think.
He said it was his cousin, so,
He knew it was there.
so he knew the bag was there, all right? Anyone else? Yes, sir.
Did they find fingerprints on the bag?
That's a good one, because then we know he actually possessed it, and that's a good one for saying that he knew that they were there. You touched it. Do you not know that we can see your fingerprints on this? So that's a good one, both of those. Anything else that would show that he knew the items were there? All right. Did he make any statements to that effect? No? Whose car is it? It's his cousin's car. How long has he been driving it? Couple days. So you've been driving a car for a couple of days, but you want me to believe you don't know what's in the back seat right there? That's a slightly implausible. What shows that the person had the ability to control the item? What showed that Danny had the ability to control the backpack? Yes, ma'am. He could reach it. He could reach it. It wasn't like it was in the trunk, right? It would be harder if it were in the trunk to prove that he had dominion, to even prove probably that he had knowledge, but yes, that he could reach it. Shared possession. What facts show more than one person might have possessed it? Someone said it earlier. It was his cousin's car. So that's a fact for shared possession. So how do all of these elements apply to this specific case? How would you think about this if you were sitting there in the jury and in the jury room and the judge told you knowledge and ability to exercise control shows constructive possession? What's going to be your conversation? You're trying to convince someone that he constructively possessed it. How would you argue that? What would you say to your fellow jurors? Yes?
Well, I mean, he was driving the car for 2 days. So, I mean, if you just used it to go up to the store and back, and that was the only time, maybe, but if you're driving around for 2 days, it's hard to believe that you didn't know the stuff that was in the back seat.
Very good comment. Anyone else want to piggyback on that?
I know people that own vehicles that have no idea what's in the backseat of their car. They never even put back there. It's just a pile of
Because I found some Tupperware stuff in the back of my Tahoe, and I'm like, who put this here? But no, but that's the counterpoint. So that's the discussion. What anyone else want to chime in about that? So he's been driving it for 2 days. You ought to know. But then we have another juror back here who said, well, shoot, I know people who put stuff in the back of the car and that's in the back of the car and they don't know. What would your comeback be? What else are you thinking?
If he knew that bag wasn't his, I don't care, it's not mine, I'm just gonna ignore it. It's just but he's blameless, he's gonna be made blameless.
Okay, so we've got 2 right here for maybe he wasn't in constructive possession. Anyone else? All right. Y'all had some really good comments about that. That was good. So you make the call for the first one. Gun under the driver's seat and the defendant's wallet is next to it. Constructive possession or no? Yes, yes. And what shows knowledge? The wallet. The wallet. Drugs in a common living room with multiple people present. Is that constructive possession? Exactly. No, it's not. That could be anybody's marijuana there. Contraband inside a book bag that the defendant admits is theirs. You said it was yours. Now, that one, you'd really want to look at that motion to suppress, because the motion to suppress in that instance for number 3 is key. Number 4, item found in a shared car with no linking evidence. Right, no, because it's just, I just drove this car. Can you imagine if you would be in constructive possession of that? Let's just say you rent a car from Avis, or you're on Turo. That's personal. You're on Turo, you rent somebody's car, you get pulled over because you don't know the lights busted out, and Officer Law says, oh, looky look, I just found a backpack in the back of this car, and it's yours, it's your car, but there's nothing else other than you rented the car. So no constructive possession. Firearm is in a closet. The defendant's mail and his clothing are in the closet. Yeah, you're going to own that one. You're going to own that one. Drugs hidden in a car that the defendant exclusively drives. Yeah, that one's going to be yours too. Very good, judges. So constructive possession. What facts strengthen the case? What facts weaken the case? We've kind of gone through this. And which constructive elements are satisfied? I think we've gotten through that one. So how many of us right now would vote that perhaps Danny defendant is in constructive possession of the things in the book bag? Let's just do the things in the book bag. How many of you feel like he's in constructive possession of the book bag? Okay. And how many of you feel like, no, he's not in constructive possession? Okay. All right. Let's keep going. Closing arguments. So closing arguments, this is what, I wanted to bring something to you. You notice that it's called opening statements and closing arguments? There's a reason, because the opening is just it's just a roadmap. It's just your statement of what the evidence is. Right, I heard it over here. But the closing, that's where you really get to argue. I mean, that's like the juicy part, right? So the characteristics, it's a summation of the evidence. The attorneys are going to make those reasonable inferences. He's had the car for 2 days, been driving it around for 2 days. He knew that backpack had a gun and oxy pills in it and the 6-7 bags of marijuana in it. You're not talking about new evidence. You don't bring stuff up that was not presented into evidence. You don't give a personal opinion. I believe this man is guilty. You can't say that. The evidence has shown you that he is guilty. Can you say that? Yes. No vouching. Officer Law has been an officer for umpteen years. Why would he lay his career on the line for Danny defendant? That's vouching. That's making him more credible. Don't inflame the passions of the jury. I'll keep going. And no burden shifting. You should have heard from Danny. If Danny was innocent, he would have told you so. Big objection. You cannot say that, because then you're saying who then has the burden of proving the case or proving that they're innocent? Defendant, and that's not the way it's supposed to work. This one, the state is supposed to prove that. That particular closing argument wasn't that, like I said, it wasn't the passionate, inflamed argument, but what he was doing was methodically getting the jury, putting the jury there when he started off with the 10 seconds and wasn't saying anything. That's how long that person had been tortured. So you feel that, you know that. And he had to do that because what he can't do is, what would you do if you had been tortured for 10 seconds? That's a golden rule violation. And that's where you're putting the jury in the place of the defendant or the place of the victim. 100% objectionable. And depending on how many mistakes had been made in the course of the trial, 30 minutes? Okay. So depending on how many mistakes had been made in the course of the trial, that could actually cause you a mistrial if you had had a series of several mistakes That's for another day. I know, right? Isn't that something? And you start the whole trial process over, from jury selection all the way through. But the point of this is for you to understand how closing arguments can be so impactful without them being colorful. That's a good word for it. Let's say colorful. Jury instructions and verdict form. We have time. I'm going to try to get this done in about 15 minutes because I need you all to be able to vote. Your jury instructions, that's the law that we are going to give to you. That's what you were supposed to follow. And we need you to follow this law in order for it to be a fair trial because you are the great levelers. We're going to give you elements of the case, what you need to prove. We're going to give you burdens of proof, explain to you the defenses, and the jury instructions, just like an opening statement is a roadmap of the evidence. The jury instructions, that's a roadmap of the law. It's not a signal of what we think the verdict should be. The jury instructions don't favor one side or another, and it is not a directive telling the jury what sentence or what verdict to reach. So we will have what's called a charge conference. A charge conference is where the attorneys and the judge, along with the parties, will sit down and they will go through proposed instructions. If you look on the Florida Bar's website and you put in Florida Bar criminal jury instructions, a screen will pop up, you click on jury instructions, and there is a list of all of the jury instructions that we use. They are standard instructions approved by the Supreme Court, and we use those in order to be able to tell juries what the law is. So during this charge conference, we will sit down and we will start with, do you have any objection to the introduction? Do you have any objection to the elements? And the attorneys are either going to have arguments for or against it. And sometimes that takes us about 30, 45 minutes, depending on how in-depth it gets. But the point is for us to have a packet of instructions that we give to the jury that will be fair to both sides, a fair and accurate representation of what the law is. We don't just come up with these instructions. We don't just make them up on the fly, for the most part. There are standard instructions that we use. Sometimes attorneys will ask us to read a special instruction. The special instruction is there because there is something about the facts that the jury needs to have some understanding of what the law is. So there might be a special instruction. Maybe it's something, a line or two out of a case that they have that will help the jury understand the law that is applied to that particular case. And those are called special instructions. And so we'll just insert those. Then we got to print out all the copies. And you all are sitting in the deliberation room going, what in the world are they doing now? That's what we're doing. We're trying to go through the instructions to make sure we have a good set to give to all of you. And so now's the time. You have heard the closing arguments. The state has said, Danny, defendant, the evidence has shown to you that Danny, defendant, is guilty. He possessed a firearm in his book bag. He possessed cannabis in little baggies. He possessed 40 pills of oxycodone. That's a trafficking amount. He's not using that for personal use. Officer Law testified in his 20 years of experience, he has always seen this as not for personal use, but he was actually selling just by the way that it was all packaged. Danny possessed the firearm. You've heard about his conviction. He's a convicted felon in possession of a firearm. The baggies, those contained all of the drugs, and so we are asking that you find him guilty of trafficking in more than 7 grams of oxycodone. We ask that you find him guilty of possession of a firearm by a convicted felon. We ask that you find him guilty of possession of cannabis, more than 20 grams. Find him guilty of possession of drug paraphernalia. Thank you. And then the defense is going to get over. They're going to be able to stand up and they're going to say, ladies and gentlemen, this is a constructive possession case that wasn't. At no point in time did you hear or see any evidence that put that gun in his possession, that put the drugs on him. The marijuana joint wasn't even there. He had been using this car from his cousin for the past 2 days. How does the evidence even come close to proving that my client was in possession of a firearm? Yes, he's a convicted felon. Yes, we admitted that. He testified and told you he had been convicted of a felony, a criminal mischief. That's what he told you. But he didn't possess a gun. At any point in any of the videos, did you see the state give you any evidence that showed he possessed that gun? No, you didn't. The evidence that you do have is that the gun was in a backpack in the back seat of the car. Can't say that. I'm about to say something wrong. How many of you have a gun and have a backpack in the back seat of your car? That you get an objection for because I'm putting you in the seat of the defendant, right? And so they'll end with something like, the state has not met its burden. They have not shown to you proof beyond and to the exclusion of every reasonable doubt that my client trafficked in oxycodone, that my client, who is a convicted felon, possessed a gun. He didn't have it on him. They have not proven to you that he possessed cannabis or that he possessed any paraphernalia. And we ask that you find him not guilty. Then the state gets to come back up on their rebuttal. And they are going to say to you, ladies and gentlemen, the law of constructive possession states that I had to prove knowledge and the ability to control. He had a lighter in his pocket, the car smelled of marijuana, and there was a burnt marijuana joint on the console. He knew it was there, he had the ability to control it. He knew the gun was in the backpack, he knew the backpack was in the car, was behind him. He had knowledge of it, and he had the ability to control it. And then they're going to go through each and every single one of those pieces of evidence and say he knew it was there, and he had the ability to control it. And with that, ladies and gentlemen, we ask on behalf of the state of Florida that you find Danny defendant guilty as charged. Thank you. And so that's how they're going to end it up, and then you've got to decide based on that. How do you decide who are you voting for, in a sense? How are you reaching your verdict? What moves you? What moves you? Yes, ma'am.
Were the defendant's fingerprints on any of the evidence?
Let's assume that they weren't. They were not. Were not. Let's assume that they were not. Does it change the equation, though, if they were? Does it change your mind? Changes everyone's mind, right? Oh, your fingerprints are there. You must have known about it. But quick question. What if he lives with his cousin and the cousin said, hey, Danny, I need about 7 of those Ziploc bags that you got. And Danny says, okay, here you go. Dun, 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 7 bags. And he goes. What if that happened? His prints are there, right? His prints are there. But does that mean he possessed the marijuana and the oxy pills? So fingerprints are nice, but we also have to look at the context. So what else are you going to be thinking about when you're trying to reach your verdict? What else moves you? Yes, ma'am.
The location of that bag, because, okay, now Danny is a felon. He knows he's a felon, and he would know that he should not possess a gun, okay? So if I'm a felon, why would I put the gun right there? I would hide it, but he did not hide it.
Well, we're not saying, he's not on trial for being smart. That's not what he's on trial for. A good thing, he should have hid it. He should have put it in the back seat underneath. That would have been great. But instead, Danny kept it in his book bag, and in his book bag was his wallet. Danny might be done. What else are you? But that's a good point. What else are you thinking about in reaching your verdict? Yes, ma'am.
Well, I'm thinking about the cousin. Mm-hmm. Like if I was the defense, I think I'd be wanting to know more about the cousin. And, is this his stuff? Just that instead of it all being on Danny.
Would you call the cousin as a witness if you represented Danny?
Well, that would implicate the cousin, I guess. He wouldn't want to, but I guess as a juror, I'd want to know more about the cousin.
I think if I were Danny's attorney, well, let me ask you this. I'm going to ask you guys. If y'all were Danny's attorney, would you call the cousin to say, is my weed? Would he do that? Do you think that?
No, because that person's not on trial. Danny is, and he's got to be proven on his own statements and the evidence that he has, that whether he's guilty or not.
But you have a juror here who would like to hear from the cousin since it's the cousin's car.
But
So,
it should have been up to the prosecuting attorney then to call the cousin and find out if that was true, what Danny was saying.
and what you do in that instance, call the cousin in, depose him, put him on the witness list, depose him, see what he says. The cousin might surprise you and say, yep, that's my car, that's my weed, those are my pills, that's my gun, period. And if you do that and the state attorney's trying to call that witness, they're like, God, dog, I got the wrong man. But the defense is going to be extremely very happy, extremely very happy. So I think it is time for us to.
Time for one question.
Yes, ma'am.
It's not necessarily a question, but it's just a comment, and I don't want to be mean, I don't want to be mean, but what if he's being set up?
What if he's being set up? What would you do then?
Call that cousin in.
Yeah, I'm calling the cousin. I'm sorry. I have, as the defense attorney, the public defender, my job is to be a zealous advocate for my client. If I got to put the cousin under the bus, the cousin, you're coming under the bus. Because I'm trying to get justice for my client. And if my client, if he doesn't know anything about that, then I need to make sure that I put on a witness who will say, no, it's mine. And here's the beauty of it. Because the state has charged Danny with it. Now, this is something that I learned as a PD. When one of my clients was found not guilty of a crime, I'm like, hey, look, but you know now who did it. Go prosecute that person. And the state attorney said, no, because we've charged your guy and we've said your guy was the one who did it, they're going to pull transcripts of the state attorney arguing that your guy was the guilty person, so we can't really do anything. So the real perpetrator in that particular case got off because they charged the wrong guy, my guy. All right, let's keep going real quick, and then we'll be able to get to some questions. Sentencing, what happens at sentencing? Here's the purpose of sentencing. We need to punish people for what they did. Let's assume Danny is guilty. Danny, I'm sorry, but I got to punish you. I've also got to consider the punishment that I give, is that going to be a deterrent? I've got a convicted felon who's in possession of guns, pills, marijuana, driving around in his cousin's car with a bad taillight. I got to put, the sentence has to be something he's going to feel that's going to stop him from doing that crime. I also got to think about public safety. Drug dealing isn't always necessarily, and you can see in this particular case, if Danny were able to get out and sell the pills and sell the marijuana, he's going to sell it to someone who very well might get hooked, right? And then that person becomes an addict, and then they have to feed their habit, and so maybe they start criming themselves so that they can feed their habit. So I've got to protect the safety of the community as well when I'm considering my sentencing. But Danny, bless his heart, he's an addict himself. So I also need to think about, do I need to do rehabilitation here? So does he need probation and maybe some drug treatment? Maybe I can do some community service and maybe that will help him get to where he needs to be as a productive citizen. So I'm thinking of sentencing, punishment, deterrence, public safety, and rehabilitation. Let's talk about some statutory penalties. Not all of these don't apply to Danny, but with a capital felony, that type of sentence is punishable by life or death. A life felony is punishable by up to any term of years, up to life. A first-degree felony, punishable by up to 30 years, second degree up to 15 years, a third-degree felony up to 5 years. First-degree misdemeanor, up to a year in jail. And up to 60 days, up to 60 days in jail for a misdemeanor. So we have the possession of paraphernalia as a misdemeanor, but all the other charges, we have a first-degree felony for the trafficking, a second-degree felony for the firearm charge, The oxy charge has a minimum mandatory. We'll talk about that. So with your minimum mandatories, in the statute, it's Chapter 893, the drug charges, you will have various minimum mandatories, and that's going to depend on how much. It depends on two things. The type of drug that you have, the more addictive the drug, the greater the minimum mandatory. And it also depends on the weight. If you have a lot, you're going to see an increase in the minimum mandatory and in the mandatory fine. As a judge, I cannot waive a minimum mandatory. The state can, but I cannot. None of us can. We have to, as the third branch of government, our job is to follow the law. And if the legislature says for XYZ crime, you must sentence them, shall sentence them to X number of years, that's what I have to do. Possession of a firearm by a felon during a felony charge, minimum mandatory of 10 years, but they've got to have actual possession. First degree murder, capital sexual battery, life is mandatory, but death is possible. If you really beat up a police officer really, really bad, 5 years is the minimum mandatory. DUI manslaughter, you're drunk, you're driving, and you kill someone, minimum mandatory of 4 years. All right.
Question?
Yes.
This might be a little bit off topic.
Go ahead.
What's the thinking around having sentencing and they're convicted of various crimes, and those sentences are to be served concurrently? Why not sequentially? What's the thinking around concurrently in terms of sentencing?
Judges, y'all help me on this one, because I think I know I think it's, when you have a minimum mandatory, your other sentences run, you sentence, and then that minimum mandatory is consecutive to whatever you've sentenced them to. We do have discretion on whether to run them concurrently or consecutively, unless there's that minimum mandatory issue. Am I right? I'm open to being wrong. It kind of like depends, right?
Depends on the nature of the offense, depends on the person's score sheet, which I'm sure it is.
Yeah, that's in your, I think I have a score sheet, that's in your materials, in your workbook.
In this issue, I would think you could run everything concurrently if you wanted to run concurrent with a minimum mandatory sentence, but those are the things the questions I'd be asking the attorney, especially the state attorney. Mm-hmm. Show me some authority that says I have to run it consecutively. But I thought you could do it concurrently.
Now, here's another thing. If we do not say consecutive, it's concurrent. Right. If we have to actually say this is a consecutive sentence in order for it to be consecutive. Because actually, this is interesting enough that I learned, it's what we say that's important, more so than what we write down. So if I say 20 years, but on the judgment, 10 years is written down, and that's what, no, let me do it backwards. If I say 10 years, but on the judgment, 20 years is written down, it's going to be the 10 years that trumps. It's what we say that's more important than what we write.
Is it because it is what is reflected on the record?
That's what, yes. It's what's reflected on the record because it's spoken.
So I know a girl who was convicted of 2 crimes of human trafficking, and her plea was 10 years, so 5 for each one.
Mm-hmm.
But I think in the courtroom, they said it was concurrent. So she should only get 5, but they changed it to 10. And
Really?
because she doesn't really know, she's wondering, can I go somewhere, can I appeal this?
Well, I can't give legal advice.
Yeah. I think she should have a 10. It's not, it's not that, but I'm just saying, I think that happened and they just realized there was a mistake and just switched it.
Help us, hold. Whew. No, I can't give legal advice, but, Godspeed. Yes, ma'am.
Your Honor, I have a question.
Yes, ma'am.
Just because I've always been curious about this. If the defendant is not guilty until, if he's
innocent until proven guilty, okay? So it's a two-part question. If the defendant is innocent until proven guilty, why do we hear in court in the light most favorable to the state? And why does the state get two parts to their closing?
Okay, so I'll answer the last question first because that one's really easy. The state gets two parts. They get an opening and then the rebuttal because it's their burden to prove the case. A long time ago, like I think it was like late 90s, early 2000s, if the defense did not put on a witness or if they only put on the defendant, they would get what we call the sandwich and they'd go first and last, but then they switched that law and now it's the state goes first and last because it's their burden. Your first question was?
Why is it in the light most favorable to the state if the defendant is innocent until proven guilty?
Okay, so after both sides, after the state rests its case, the defense will make a motion for a judgment of acquittal. And what they're saying to us is, Judge, they haven't proven this case. I want you to grant my JOA and take this case away from the jury because there is nothing in dispute here. There is nothing for the jury to have to, no questions for the jury to answer. So the standard, according to the case law, is that we have to take the evidence, we have to give the state the benefit of the doubt. So we will say, judgment of acquittal is denied, taking the evidence in the light most favorable to the non-moving party, here it is the state, I'm going to deny the judgment of acquittal because they're getting the benefit of the doubt at that time. That's why, in the world according to Tanya, that's why it's done. Judge Dubois, Judge Egan.
I agree.
Say you agree, please. Great.
I agree.
Great, great. Great question, though. Very good question, because I've never even thought about that, but yeah, why do we? Because he's the one who's presumed to be innocent, unless and until the state proves that he's not, right?
And there is sufficient evidence to go to the jury.
And there's sufficient evidence to go to the jury. There's a question. There's a factual dispute, right? Any others? All right, so let's see, where are we now? Time for you to vote. I need you to get your phone out, please. You're going to use the Google form. I'm going to need you to answer the questions. It's just whether you're going to answer whether or not he's guilty. And then I'm going to look and see how you all voted.
Tanya, do you have time for a question?
I have time for a question, yes.
What if the jury doesn't know that he's a convicted felon? Because
They
a lot
will.
of time during trials, those type of stuff are suppressed. The defense can go and ask for the priors to not be introduced to the jury.
They come into play if he testifies. So if he testifies, then he can be impeached with his prior criminal history. Let's say he did. So now you all know he is a convicted felon. I'm going to need... I got to get my laptop because it's not... Are you all still voting? I hope so. Poor Danny. All right, has everyone voted? No, I still see some numbers coming up. Everyone's finished voting? That's me looking at my responses. See, and I can do it by the question. All right, so I think I have everyone here. Everyone's voted. So now when you all vote, you'll knock on the door, knock, knock, knock. The deputy will tell you, you'll say, we have reached a verdict. And that makes all of us happy because, whew, there's no mistrial, we don't have to try it again. So then you all will come back into the room, and the judge will say to you, ladies and gentlemen, my understanding is that you have reached a verdict in this case. Yes, Your Honor, we have. Please pass your verdict form to the deputy. The deputy gets the verdict form, gives it to me, and I get to see the verdict first. But I am looking at the verdict form to make sure you have checked off all of the blanks and to make sure that you have signed it. It's not just so that I know first what's going on. And then the clerk will, I'm sorry? I can do a poker face. That is the only time in my life I can do a poker face. Every time else, I'm bad. And so then the verdict is read. So here we go. In the case of the state of Florida versus Danny defendant, we, the jury, find the defendant guilty of trafficking in 14 grams or more, but less than 28 grams of oxycodone. As to count number 2, we, the jury, find the defendant guilty of possession of a firearm by a convicted felon. As to count 3, we, the jury, find the defendant guilty of possession of more than 20 grams of cannabis. And as to count 4, we, the jury, find the defendant guilty of possession of drug paraphernalia. There were 12 who found him not guilty on all counts. Oh, Mr. Sotomayor, why do you steal my thunder? And so after that, someone's going to ask, poll the jury. Judge, may we have the jury polled? Juror number 1, what is your verdict? No, juror number 1, is this your verdict?
I'm not going to say.
You have to, unfortunately. Pretend and say yes. You five right here, pretend and say yes.
Yes.
Is this your verdict, juror number 2? Is this your verdict, juror number 3?
Yes.
Is this your verdict, juror number 4? Is this your verdict, juror number 5?
Absolutely.
Oh, wow, that's a good one. And because we have 6, is this your verdict?
Yes.
The jury is unanimous. And then after that, I will say, ladies and gentlemen of the jury, we thank you very much for your service today. No one can be forced to talk about the jury's deliberations except by court order. Sometimes the attorneys might try to talk to you about your verdict because they have questions, or some might seek to find fault with you, but it is going to be left up to you as a juror to decide whether to maintain your privacy or not. And so on behalf of the Chief Judge, Lisa Munyon, and all of us here, thank you for your service. This matter is adjourned. And the trial is over, just like that. That's the trial. But we still have sentencing. I can do it in like 2 seconds, watch. Sentencing. How would you sentence him? Trafficking in count number 1 is punishable by a minimum mandatory of 7 years, so he has to do 7. He's got to do 7. His fine is $100,000. On possession of a firearm by a convicted felon, he can get up to 15 years. Let's assume he's scoring prison. How much time are you going to give him? The minimum? The minimum, he has no minimum mandatory in that one, Dahlia. Oh, who's the ventriloquist back there? Okay. So there isn't a minimum mandatory on the possession of a firearm by a convicted felon because he wasn't in actual possession. So what are you thinking? Maybe like 2 years, 3? Something like that. Marijuana charge, how much are you going to give him on that one? He's punishable by up to 5 years. None on the marijuana? Okay. We might do credit for time served and just run that concurrent because we are required to give an individual credit for time served. If they have spent 20 months in jail waiting for the trial, we have to give them credit for time served. It's an illegal sentence if we don't. Paraphernalia. Time served. Are we running them concurrently or are we going to run them consecutively? Y'all are concurrent? I think I would do concurrent even if I let me just stop. I'd follow the law. Okay. Any questions? Yes, sir.
We never heard if he made bond.
Oh, no, let's say this. Pretrial detention. Because of the nature of the drugs and no, you can't get it you can get it for fentanyl. Let's say it was fentanyl. He could get pretrial detention being held on no bond for that, but not for any of his other charges. So he probably posted bond, maybe $100,000 on count number 1, perhaps.
Maybe he served the weekend and that time served.
Those 2 days, 3 days would be time served, but his lawyer might tell him, hey, look, it might be better for you to just stay in jail because I don't quite know what's going to happen with this. I have 30 seconds, I think. Yes, ma'am.
Okay, so you have to do the minimum mandatory on the drug charge for the trafficking, but say the score sheet, he scored 32.3 months at the bottom.
Would you have to give him the 32.3 months?
Yeah, I do.
And not the 2 years probation?
I have to give him his 7 years in prison because that's the minimum mandatory. And the minimum mandatory is what trumps it. So let's say this.
But then could you give him a time served on the rest of the accounts?
could.
Even though on the score sheet he served the 30, or he scores the 32.3?
Yes, I
Okay.
can. If it were 22 points that he had, it would be discretionary, but I'd have to write an order out explaining written findings on why I'm giving a person who's not scoring the 44 points, but scoring only 32 points. Why am I sending him to prison on a charge that's not scoring prison? So you just have to make written findings. If the minimum mandatory is higher than the statutory maximum, I give the minimum mandatory. I can't give the statutory maximum because the minimum mandatory is going to trump. So let's say the statutory maximum was 5 years, but his minimum mandatory is 10. I have to sentence him to 10. Eee, that's why I said, poor little Danny defendant. All right, I'm 1 minute overdue. I do want to thank all of you for being here with us, but there is one that I must thank. Judge Egan, I want to thank you for your dedication to inside the courts and to education altogether. We will miss you greatly. We will miss you greatly. We really will.
I will miss you more, okay? Margaret, thank you very much for this lovely card. It's so thoughtful. And thank you, everybody. Again, this has been one of my, been one of my favorite projects as a judge, and I will miss it. I have left you in very capable hands, Judge Eric Dubois, one of the best judges we have here, and he's going to do a fabulous job, okay? So I'll miss seeing all of you. I think I'll pop in and be an observer next year, okay? Please. I got lots of questions for you, Rob. I have lots of questions, okay? But thank you all so very much. I know if anyone wants a picture with Judge Wilson, she will accommodate you, okay? All right? And please drive safely. All right, we'll see you all soon.